Okay. Hello, everyone. Hello. Welcome to Focus on Liberia. Welcome to Focus on Liberia. We are live right now at the Temple of Justice, and we are attempting to bring you live reports from the ruling today by the Honorable Supreme Court concerning the Bill of Information between the what has become known as the Majority Bloc and the Rule of Law Caucus. So we're attempting to bring you those reports now live. Hang on, stick with us, and we're going to work out a few technical modalities here, and we should be going back to our live report from the Liberian Supreme Court bench. Stick with us here. There we go. We are coming to you live. So time is far spent and we are far behind. So how about we go directly to the bench and listen to the Chief Justice, Her Honor Sewell, give her ruling, and then we'll come back and do analysis.
As well as Rules 10 and 48 of the Rules and Procedures adopted by the House of Representatives of the 55th Legislature. In his returns filed on November 26, 2024, Representative Richard Nangwe, designating himself as Speaker on behalf of those representatives supporting his position, prayed this Honorable Court to deny the in-brief petition filed by Councillor J. Fonati Kofa, Speaker of the House of Representatives and representatives of the 5th Legislature. Representative Kuhn asserted the following: that the removal of Honorable J. Fonati Kofa, Edward Flomo, Abu Kamara, and Marvin Cole from their respective positions in the House was a purely political matter and not justiciable before the Supreme Court. That consistent with prior opinions, the Supreme Court has refrained from addressing political questions. That consistent with prior opinions, the Supreme Court has refrained from addressing political questions, that the Constitution grants the House of Representatives the authority to promulgate rules, hold quorum, and expel its members under rules adopted by the House, that all individuals listed in the in-brief petition were accorded due process of law and were subsequently removed for violating the rules of the House of Representatives, that Councillor J. Fonati Kofa was removed based on charges of corruption and unethical conduct, that Edward Flomo, Abu Kamara, and Marvin Cole were removed on charges of unethical conduct that impeded the work of the House of Representatives, and that under the doctrine of separation of powers, the Supreme Court cannot review the decision of the House of Representatives to remove these members who were investigated and found in breach of the House's rules. Upon review of the various contentions advanced by the respective parties in the in-brief petition, this court noted the following pertinent issues for consideration. 1. The jurisdiction of the Supreme Court to adjudicate issues arising from such internal disputes among House members was explicitly challenged. And 2. That both parties sought the interpretation of Articles 33 and 49 of the Constitution to support their respective actions and or sides. In our determination of the issues advanced by the parties in the in-read petition, this court opined as follows. 1. As to the Supreme Court's authority to adjudicate cases arising from internal disputes among members of the House of Representatives, this court opined, and I quote, predicated upon its authority articulated in Article 66 of the Constitution, the Supreme Court does have jurisdiction to decide allegations of violation of the constitutional rights of members of the legislature, even if arising out of internal wrangling among the members of the House of Representatives, as seen clearly falls within the purview of Article 66 of the Constitution, unquote. In this regard, the Supreme Court noted that although the petition filed by Speaker Kofa involved an internal dispute within the House of Representatives between Councillor J. Funaki Kofa and certain members on one side and Representative Richard N. Home and other members on the other side, the crux of the dispute between the parties poses a constitutional crisis, thus vesting the Supreme Court with the authority to delve into same. Accordingly, we reaffirm this position of the court as was done in the December 6, 2024 opinion. This court emphatically declares that it is within the power and authority of the Supreme Court of Liberia to say what the law is without fear or favor, irrespective of the parties before the court. That pursuant to this constitutional authority, the Supreme Court can and will address any allegation of a constitutional violation within any branch of the government. 2. As to the interpretation of Articles 33 and 49 of the Constitution, this court unequivocally held that, and I quote, a simple majority of each house shall constitute a quorum for the transaction of business, that whether a simple majority is sitting or lower number, in both cases, the presiding officer defined in Article 49 of the Constitution is the Speaker, and in this case, Speaker J. Funaki Kofa, who was duly elected, presides over the House's functions, except absent or removed as required under Article 49 of the Constitution and the rules of the House of Representatives, that is rules 9, 8, 9, and 10. The Supreme Court has consistently held that in interpreting the provisions of the Constitution, statute, or all provisions or sections relating to the same subject or provisions having the same general purpose to be construed together as though they constituted one law or one provision, and that they must be construed, governed by one system, one spirit, and policy. Predicated on this principle of law, the Supreme Court interpreted Articles 33 and 49 together, given that each provision complements the other. In application to Speaker Kofa as regards these two provisions, we opine and held that, and do hold now, that although Speaker Kofa, who at the time was presiding over a minority membership of the House of Representatives, and as such could not Rule 21 of the House of Representatives and penalize absentees in a manner deemed appropriate, as saying had to be done in consultation with plenary, which requires a quorum, and he not being able to form a quorum for plenary as the absentees comprise the majority of members of the House. The Constitution, statute, and rule and House rules are all silent as to how the minority is to compel attendance of absentee members who insist on being absent. We therefore are at a loss. We are therefore at a loss, as there is no enabling statute promulgated or standing rules setting forth the process for compelling said absentee members to attend sessions as envisioned under Article 33 of the Constitution. Also, in application to the respondents, this court noted and notes even now that in addition to Articles 33, Rule 7, 7.2, 8, 8.1, and 12 of the House of Representatives of the rules of the House of Representatives provides that, and I quote, a quorum shall consist of simple majority of the members of the Honorable House of Representatives, which shall be necessary for the transaction of business. However, a minority may meet from day to day. Meetings at which a quorum is not present, only a motion to compel the attendance of absent members or to adjourn may be made, unquote. Therefore, even though the respondents comprised of a simple majority, it was not only necessary but constitutionally mandatory for said quorum to be presided over by the presiding officer defined under Article 49 of the Constitution as the Speaker, that is Speaker Kofa, and only in his absence the Deputy Speaker. Having expounded on this court's decision in the in-read petition, we are now left to determine whether or not either of the parties pursued with this court's declaration of December 6, 2024. As we stated supra, the informants listed a number of actions which they allege amount to violations of this court's mandate in the in-read petition. Beginning with the informants, we emphasize that we see no promulgation of an enabling statute as to how Article 33 of the Constitution of Liberia can be executed by the presiding officer, whom we have held pursuant to Article 49 of the Constitution is the Speaker, that is Speaker Kofa. And unfortunately, he has presented no means as to how he, the constitutional presiding officer of the House of Representatives, can compel absentee members to attend a session for the purpose of obtaining quorum for the transaction of business. What is before us is this amended bill of information, an amplification of this dilemma, which we stated in the court's previous opinion of December 6, 2024, when we declared that setting a sanction to compel attendance by the simple majority was without the ambit of the court, as this Supreme Court does not make laws. Besides, it will be in violation of the Constitution on separation of powers. In a situation such as this, where a majority of the members of the House of Representatives refuse to sit under their elected Speaker or to have him removed as the Constitution dictates, this court can only speak to said violation as being in total disregard to the law which members of the House of Representatives took an oath to uphold and protect. As to the respondents, we similarly ask the question, have you pursued this court's declaration of December 6, 2024, especially as we have espoused herein. It is common knowledge that the members of the House of Representatives are or have been conducting a parallel House with a minority group meeting and presided over by Speaker Kofa and his self-styled majority group of black and the self-styled majority group of black. These parallel sittings and or actions lack legal foundation either by the dictates of the Constitution or any other laws within this jurisdiction. Additionally, we take judicial cognizance that during the hearing and determination of the in-brief petition, the respondents firmly argued, as stated in their returns, that they expressed a vote of no confidence in the leadership of Speaker Kofa, that their quorum in the joint chambers of the legislature was legitimate for the transaction of business since they met the constitutional requirement of a simple majority as prescribed in the Constitution and the rules of the House of Representatives, that their quorum was being chaired by a presiding officer in person of the Deputy Speaker, who is legally clothed with the same authority as the Speaker to preside over their deliberations in the absence of the Speaker. And we emphasize absence while we paraphrasing what the respondents said in their return. During oral arguments before this court, one of the counsel representing the respondents was asked a question by the court as to the whereabouts of Speaker Kofa at the time Deputy Speaker Thomas Pala was acting as the presiding officer during the parallel plenary session in the joint chambers of the legislature. In response thereto, the respondents' counsel stated that Speaker Kofa was, and I quote, in another room, unquote, within the confines of the legislature. This response by the respondents' counsel raises the cardinal question of whether the Deputy Speaker or any other representative could legally act as presiding officer for a plenary session of the House of Representatives in the wake of the Speaker being present and available to perform his constitutionally delegated task with state and emphatic no. Speaker Kofa not being absent to preside over plenary sessions, the Deputy Speaker or any representative for that matter could not legally preside over any plenary session, even if said session met the simple majority criterion for the transaction of business, and no action therefrom can be considered by this court as constitutional. Therefore, any action or sitting by the majority to the exclusion of the Speaker presiding while he is present and available to preside is unconstitutional and without the pale of the law, and we so hold. This was held in the case Quack versus Jala and Ball Supreme Court opinion, October 3rd, 2014, that, and I quote, the Constitution provides the framework within which the legislature operates, and any act, including a vote of no confidence that breaches constitutional provisions on due process, shall be subject to judicial review, unquote. Moreover, the purported quorum, which the respondents claim to have had to conduct official business of the House of Representatives, was done in the joint chambers of the legislature whereas the speaker who was available, which time is considered to obey the respondents in both their returns and oral arguments before the Supreme Court, was convening session in the plenary chambers, which is the official place for sitting for the plenary session for the House of Representatives to conduct official business. The resolution of this present crisis amongst the House of Representatives does not lie solely with the court to say what the law is, but adherence to the mandates and directives of the Constitution is divulged upon every citizen and all authorities within the country. Therefore, all authorities and officers of the state, whether the legislature, executive, or judiciary, or officers of government created by and exercising powers pursuant to the provisions of the Constitution, are expected to meticulously abide by all constitutional mandates and directives. This court in the case CPP versus NEC, Supreme Court opinion and versus NEC, and the Honorable House of Representatives and the Executive Branch, Supreme Court opinion October 10, 2020 stated, and I quote, that constitutional mandates are absolute rules of action and decisions for those who are required to exercise them. Failure to abide by the mandate of the Constitution is repugnant to this supreme and paramount law, and said disregard for the constitutional mandates exposes the nation to lawlessness and poses the risk of undermining the democratic and law-abiding culture for which the Constitution was promulgated, unquote. Having clarified our opinion and judgment, the further question of concern now is whether the bill of information will lie in the instant case. During arguments of the amended bill of information, one of the counsels for the informants strenuously argued that the respondents violated the mandate of this court by the commission or omission of actions enumerated in the amended bill of information. Therefore, the informant prayed that this court enforce its mandate contained in the December 6, 2024 opinion and judgment of the in-brief petition. When he was also asked to say what the mandate of this court was in the in-brief when he was also asked to say what the mandate of this court was in the in-brief petition, he answered that the mandate is encapsulated in the concluding paragraph of our judgment, which reads as follows, quote, wherefore, in view of the foregoing, any statements or actions by members of the legislature not in conformity with the intent of Articles 33 and 49 of the Constitution are authorized, unquote. On the other hand, and as earlier stated in his opinion, one of the counsels for the respondents, also relying on our judgment, argued that the respondents did not violate this post mandate and therefore urged this court to be put definitive and exact in its disposition of this amended bill of information, so that its ruling of December 6, 2024 will not be susceptible to more than one interpretation, unquote. In a plethora of Supreme Court opinions, this court has unwaveringly and consistently recognized that only a bill of information can remove uncertainty from its judgment or correct the enforcement of its judgment. And we have a variety of cases there, starting from 2000 to 2015. Now, since it is obvious that all the parties before the court, including the Minister of Justice, seem to be at variance with respect to what constitutes our opinion and mandate of December 6, 2024, and have advanced their own personal interpretations of what the law is, it is imperative that in keeping with our precedent espoused in the aforementioned cases, it is necessary for the purpose of constitutional clarity and respect for the rule of law to grant this bill of information insofar as it relates to the parties' uncertainty of the December 6, 2024 opinion and judgment of the court. Wherefore, and in view of the foregoing, the bill of information is granted for the reasons stated herein, and the court majority block unquote are hereby mandated to operate in accordance with the Supreme Court's interpretation of Articles 33, and 49 of the Constitution as contained in the court's opinion and judgment of December 6, 2024, and further clarified in this opinion. The clerk of this court is hereby ordered to inform the parties of this court's decision, and it is hereby so ordered.
So, folks, you.
Now, Mr. Clerk, before you.
So, Michael, there you have it. You are muted, Michael.
Thank you so much. All right, to our audience, thanks for joining us. We have been looking at the ruling from the Honorable Supreme Court. We will be joining some of our panelists shortly to give their input on what we've heard so far. We also will be opening the lines, hopefully, and getting calls in as well. So if you all can remember, if I give you guys a short review here, Honorable Fonati Kofa was subsequently attempted to be removed as Speaker of the House of Representatives, and that did not go so well. There was contention concerning the number of votes that was needed and if it had been given. And then we saw a majority group of the Honorable House of Representatives move to a different section in the building where they started to hold session there. And over time, they were able to gain the presence of the Deputy Speaker, Thomas Fala, who then began to preside. And as we watched that, we saw on numerous occasions that Speaker Kofa was not able to get a majority sitting and thereby hold session. And then we saw the majority bloc hold an election under which Richard Cohn was elected on a white ballot. And at that time, We saw the formation of Speaker Kofa and a group of lawmakers, including Honorable Musa Hassan Bilate and many others, formed a group called the Rule of Law Caucus, and um, pers- they then went on to the Supreme Court and asked the Supreme Court to make a determination on what they term as the unlawful removal or attempted removal of Speaker Kofa. There was a ruling by the Honorable Supreme Court, what has come to be known as the ultra virus ruling. Both sides celebrated after that ruling. There was much confusion in the country concerning what exactly had been ruled and what were the expectations. We saw different interpretations from various legal entities, including the Minister of.
Michael,
Yes.
let's go back. Let's go back to the hearing.
Okay. You're back on? Okay.
Set a procedure for compelling members who fail to attend the session. This court, as it has stated, cannot intervene by setting a procedure for the House of Representatives, which will amount to a violation of the Constitution of the three branches of government under Article 3. Second, the role of the court is to pronounce what the law is through a judicial function of interpreting the law in each case. In the current controversy, this court was clear by declaring that any setting of the legislation not consistent with the intent of Article 3 and Article is ultra virus. The responsibility to adhere to the provision of the two articles rests with the House of Representatives, who are lawmakers and who should know that the Constitution is the supreme law of this country and its provisions are binding on authorities, including the legislature, Article 2. Moreover, the legislature under Article 21 of the Constitution took the solemn oath to uphold and defend the Constitution and the laws of the Republic. Thus, their action must be consistent with the oath they took. The other observation I make is that our government under Article 3 of the Constitution consists of three separate branches. Three separate coordinate branches, in my opinion, speak to the relationship between the three branches for the effective and efficient running of the government to preserve law and order and maintain peaceful coexistence. If one branch fails this responsibility by ignoring the Constitution and the laws of Liberia, that is pushing the country into dangerous territories and unhealthy for our nation. My final observation is that the House of Representatives has placed itself in the power struggle motivated by politics, which this court should be cautious not to be in the center of such a conflict. But the duty of the court, as I said, is to state the law, to say what the law is, and not engage in political dispute as it is in the instant case. The first issue I have identified is the office of the Bill of Information. Public directly whether the Bill of Information will lie in the instant case. I answer in the negative. Rule 4 by 12 of the revised rules of the Supreme Court of Liberia prescribe the office of Bill of Information as follows. Quotation opening. The Bill of Information will lie to prevent a judge or judicial officer who attempt to exclude the mandate of the Supreme Court, who attempt to execute the mandate of the Supreme Court in an improper manner from doing so with the judgment and or mandate of the Supreme Court. B. The Bill of Information will also lie to prevent anyone whosoever from interfering with the judgment and or mandate of the Supreme Court. From the above rule, it is profoundly clear that the Bill of Information in this jurisdiction, in its legal content and application, is an exclusory proceeding that complains of the judge or judicial officer who attempts to execute the mandate of the Supreme Court in an improper manner, or any person who interferes with the mandate of the Supreme Court. in the woman, yes, the judicial officer or any person whosoever who are contrary to the mandate of the Supreme Court by disobeying, interfering, or obstructing the mandate of the Supreme Court. In consideration of the whole rule, I ask what the mandate and the judgment of the Supreme Court of December 6, 2024 constitutes the mandate, order, or instruction to anyone. The answer definitely is no. The mandate is essentially an official order or instruction. In the legal context, it is a document that emanates from the higher court to the lower court that tells the lower court what to do next after a decision has been made by the appellate court. The mandate is a formal order from an appellate court to a lower court, notifying the lower court of an appellate court decision and directing the lower court to act accordingly. Line law dictionary definition. In the application of the definition above put there are two things that stands out: an order or instruction from the appellate court, and the lower court is directed to do an act. In my mind, there is no mandate from the Supreme Court to the lower court in the December 6, 2024 judgment. This is the case involving controversy between members of the House of Representatives and the court, and the court was called upon to interpret the law, specifically Article 33 and 34, relevant to the action of the members of the House of Representatives. This court, being mindful of the constitutional crisis that would have granted and issued a mandate to the members of the legislature, refrain from doing so, and by the way, to the Supreme Court, instructed the members of the House of Representatives to stop voting session, be it minority or majority, secondly last. As such, the mandate being sent to the mandate to the members of the House of Representatives and not obey. The Supreme Court would have created a risk and the crisis that would challenge its authority. In other words, the Supreme Court cannot legally hold the members of the House of Representatives in contempt for disobeying the order of this court. Because enforcement of a contempt against members against another branch of government will create a legal form of authority. Of course, the recourse to the judgment of the Supreme Court, the relevant part thereof is quoted below to address the issue of the mandate. Hence, members of the House of Representatives are to conduct themselves accordingly. The plan of this court is hereby ordered to inform the party and it is hereby to order. Secondly, there is nothing in the statement, this statement that constitutes a mandate from the Supreme Court. The only order here is given to the client, and the only thing the client is required to do is to inform the parties. The mandate of this court has always been declared directly to the lower court to do an act specified. The Supreme Court, in giving a mandate, does not inform the lower court. It directs. Hence, the Supreme Court ordered the client of court to inform the parties of its judgment without any instruction or direction to the parties. More besides, the prayer of the current informant really does petition cooking. Hereby pray to declare the action of the proposed Speaker Kung and members of the majority grant law and power admission and session hearing decision that violate the court's ruling and final judgment of barrel and unconstitutional. The question my colleague choose to know is how can the Bill of Information act to declare action unconstitutional when the Bill of Information is supposed to be ordered? In the Bill of Information, the prayer can never legally be a request to declare an action or to declare an action unconstitutional act and illegal as contained in the current informal prayer put above. The prayer for the Bill of Information is to punish the respondent for violation or disobedience of the court mandate. But on the contrary, as quoted above, the informant herein asked the court to redeclare unconstitutional or other what the court had earlier declared in 8 December 2014. And unfortunately, majority police proceeded to redeclare, re-clarify, and explain the judgment of December 2024, contrary to Rule 4, Part 12 of the Supreme Court. This is not and has never been the office of the paper information. It is overall departure from the rule of the Supreme Court. The action by my esteemed colleague has created a Pandora box and leaving many questions to answer, wherein anyone who sees the certified with the Supreme Court opinion in the vision will refer to the Supreme Court via a bit of information to explain, declare, and restate the court judgment. This is unheard in the history of this court, of this court. I am of the strong conviction that whether right or wrong, the informant bill or information came to this court through an improper manner or in a like pattern through a back door, and therefore unacceptable in the case of Rule 5 by 12 of the current Supreme Court rule. This court cannot and should not encourage the party litigant to pursue what may be their right through a wrong path, as true wrong cannot make it right. My opinion, my majority colleague cannot disagree with me that the petition for you read the Constitution is a declaratory judgment, because it pray for a request to the court to declare certain act or law unconstitutional. So when such act or law is declared by the court, any party who feels strongly that the right declared by the court have been violated has the right to proceed to the appropriate tribunal to establish and prove who violated his rights, where they were violated.
What you are listening to is a dissenting opinion, and what he's saying basically is the court has no place to do ruling on a bill of information. In fact, he's saying the bill of information was submitted through an improper manner or through the back door. Let's continue to listen.
I recently at 2020, in the case Equa Bank for Investment and Development versus United Commodity Incorporated, the declaratory judgment was filed in the civil court, and the losing party prayed for a plea to the Supreme Court. The Supreme Court having heard the opinion, amended on the civil court to resume jurisdiction and impose the payment of the money judgment. That mandate of the Supreme Court was challenged through a bill of information, and this court was compelled to concede and will consider the signing of the bill of information and rule reverse itself and send order below for the party who right was declared to file an appropriate action. Accordingly, the appropriate action was filed, and as we speak, the trial is proceeding before the proper court below. It is unfortunate that my majority colleague, as recently as 2020, are pursuing the same error. I conclude that there being no mandate from the Supreme Court, the bill of information does not meet the requirement of Rule 5 by 12 of the revised rules of the Supreme Court and the law. Hence, the opinion and judgment of my majority colleague is a slap in the face of justice. In my opinion, the judgment of my esteemed colleague is unfortunate, and it is a miscarriage of the law. Now coming to the second issue, whether the passage into law of the budget of the fiscal year 2025 by the majority bloc of the House of Representatives and subsequently confirmed by the Legislative is to do that as arranged by the informant. In addressing this issue, I must consider the political and legal act and experiences under the circumstances of this case. Though an impasse exists in the House of Representatives that has divided them into so-called majority and minority bloc, they still have the right to sit in spite of the Supreme Court decision for December 2024. as earlier indicated in this opinion, that some people have no authority whatsoever to stop another branch of government from performing its constitutional duty. The majority bloc was certain to receive a draft budget from the fiscal year 2025 from the clerk of the House of Representatives, which was submitted by the President of Liberia. The majority bloc deliberated on the draft budget and passed it, then submitted it to the Liberian Senate, which concurred by confirming the act of the majority bloc with respect to the passage of the budget. Here a political decision was made by the majority bloc and the House of Senate by taking action to pass on the draft budget. Now we're saying the impact at the House of Representatives. Following this political decision, the majority bloc and confirmed by the Liberian Senate, the budget was submitted to the President of Liberia to sign, which he did in line with his official duty as President of the Republic of Liberia, head of government and chief executive of Liberia. The experience of these actions cannot go unnoticed by any reasonable man, and this book is not on the way to what you have enlarged into an eminent career in the government of Liberia. And recently, the circumstances that would have led to a year and total collapse of the government of Liberia. The President of Liberia, in keeping with his constitutional duty as the head of state and chief executive, is required to submit a draft budget for each fiscal year to ensure the operation of the Liberian government, pay salary, pay obligation of the government, and provide operational expenses for the three branches of government. And by law, the fiscal budget for 2025 should have been submitted to the House of Representatives before October 10th of 2024. What then would the President have done in the midst of the divided members of the House of Representatives? Wait until the government collapsed because the fiscal budget had not been passed? Indeed, that would have been an unmanful act for non-functional government to head. In his position as President, head of state and chief executive, he proceeded to submit the draft budget to the clerk of the House of Representatives, which the majority bloc took cease of. As I recall, at the time the Supreme Court rendered its decision on December 24, the President was nearly late by 2 months to comply with the budget law. Giving order to the above circumstances, the executive branch of government of Liberia acted promptly and politically by signing into law the budget that has been passed by the majority bloc of the House of Representatives and the Liberian Senate for the survival of the state history. Thus, this is now the 2025 fiscal budget which this government is utilizing to operate, which every branch of government is drawing on. Moreover, the act of the executive in presenting the 2025 fiscal budget, irrespective of the legislative power, is in line with the concept of self-preservation of state. This doctrine of international law refers to a state fundamental need to protect itself, its citizens, and its interests from harm or destruction, often in the face of external threat or internal instability. The executive action also finds support in public policy. As head of government, head of state, head of the government, and commander-in-chief of the armed forces of Liberia, and officially the president exercised expediency and approval power under Article 35. And as a consequence of this, he signed the budget into law after the usual concurrence granted by the Honorable House of Senate. Moreover, in the action of the solution to the legislative problem, the President could not wait for the state machinery to run to halt because of the deadlock at the House. This would have certainly had a security implication and other implications wherein the entire functionary of the government would lack due to lack of operating budget to keep health facilities, school facilities, and other functionary of the government including the judiciary from performing its duties and functions. I now come to the third and final issue, the functioning and operation of the government under the budget of 2025. The question is, may the majority block of the House of Representatives or any branch of the Liberian government receive benefit under the same budget and then challenge it, legality? I answer no. I also answer in the negative. In the case that would be operating company versus Assad, Edion, the one era decision, 49, 1983. Number one who knowingly accept the benefit of the country or conveying the escape from denying the validity or banning effect on him of such a contract or conveying. Unquote. There will be an inconsistent position to benefit from the budget of 2025 by receiving salary and then seek to challenge its legality. This brings to mind the majority black position that the budget has passed is illegal. Then they cry out that they have been denied salary for which they resorted to the Madam proceeding before this vote. The question then is under which budget they seek to recover their salary. Are they seeking salary under the same illegal budget of the 2025 declared illegal? In my mind, this is among to a contradictory position which I cannot sustain. Expanding this question further, may any branch of the government seek to benefit from the budget of 2025 and then declare saying illegal? And this question is more to be considered by this court. Secondly, currently the Liberian judiciary, like the other two branches of government, is receiving salary benefits and operational expenses under the 2025 budget. In the wisdom of the court, could it declare the budget illegal? I think doing so is preposterous because the consequence will be producing chaos and collapse of the government for lack of money to operate, and the judiciary will be paralyzed. The court is clarified and should be reasoning in applying the law in the light of the circumstances of the particular case as in the instant case. The preservation of our government, maintenance of security, peace, and order in our society are embodiment in the judicial pronouncement of what the law is. Hence, the action of the president as the head of state, head of government, and commander-in-chief of the armed forces for Liberia to prevent here, would have made us to sit here today as justices, fans supporting law, experiencing public policy. As the prime duty of the constitutional code is to interpret the law for the safety and survival of the state. But these stated reasons above, I respectfully will my signature from the majority opinion of this court as bill of information will not legally lie. I further hope and pray that the opinion of the majority will be recalled in a sooner immediate future. And respectfully so.
There you have it.
Yes,
That was
Justice.
Justice Bissy. We're going to listen to the next justice here. Hold on.
I think what happened here right there will do a lot of damage coming up in the next couple of weeks.
What do you mean? What happening? So
What happened?
we have the Chief Justice who delivered the Supreme Court opinion or delivered the bill of information, and then you have Justice Bissy with a dissenting opinion. So what are you talking about?
What I'm saying is this only reinforces the idea that the Unity Party has been, propagating. That how can a Supreme Court say that their action was wrong when they pass a budget through, Coons block, and the justices on the Supreme Court benefited from that budget? So they will be almost trying to say that they admitted that they were, having paid their paycheck were illegal, and they were getting paid illegally through an unconstitutional passage of the budget. So this brings in a constitutional conundrum that how can you say that the speaker is unlawful, they acted unlawfully while the speaker Kofa was in the same house of representative as they were, and then the president sent a budget to them and they passed a budget and you knew about this and you accepted the proceeds from that budget as your salary. So it's a
Right.
conundrum, and that's what the Unity Party is going to run with.
All right. So for the sake of our audience, let's take it one at a time. And even though we are not lawyers, but what we heard from the starting with the Chief Justice and then Justice Wese, who delivered the dissenting opinion. Ladies and gentlemen, if you're just joining us, this is Focus on Liberia, and we are live from the Supreme Court, where the Bill of Information prayed for by Embattled Speaker J. Funati Kofa is being delivered by the Honorable Supreme Court. And our colleague, Prince Momba, is right there at the Supreme Court, and we're going to be getting reactions from people, based on what we've heard so far. Michael? So, Mr. Padmo, let's delve into it. What did you hear from the Chief Justice, and then we come to the dissenting opinion from Justice Wese?
Well, it's I'm anticipating, what we're gonna get here coming up, from these people. Hold on one second here. I'm anticipating the feedback we're gonna get. I'm even more excited about the feedback and what I'm gonna get from the Liberian people than even the judgment. I listened as much as I could to the judgment, and I was still a little, because I was in and out, but then I listened very keenly to the dissenting opinion, because dissenting is always the opposite of the judgment. And from the dissenting opinion, it tells me from that Funati Kofa has won a great victory here today.
Right.
And the key information here is that the Chief Justice opinion was the majority opinion. That means that opinion prevails over the dissenting.
Right.
Yes.
So the Chief Justice started by first defining their jurisdiction. Say, we have the jurisdiction to look into this matter, because that was one thing that they were all saying. Say, hey, we have 3 branches of government. You have no fish to fry. What's going on on the Hill? Now she's saying, no, that's not the case. And she also said we're going to combine Article 33 and 49. So just like what they said before, that Funati Kofa's group did not have the majority or did not have a quorum. She defined quorum. You don't have the quorum. But then she also said the other group, even though you have the quorum, but you cannot do anything. You cannot preside when the duly elected speaker is around. And the plenary where the Kofa group was meeting, that's the according to her, that's the place that that they've always met. So going somewhere else to decide anything, whether you are deputy speaker or whoever you are, whatever you do there is unconstitutional. So that I think that's very key. Declaring what they did as unconstitutional. He said the majority block was presided over by the deputy speaker, but Speaker Kofa not being absent, that does not give them the right to do anything. And plenary is the official place for the House to meet. So you can go outside of that and do anything. Now, Justice Wese is coming up with the dissenting opinion and say, hey, wait a minute. In fact, the Bill of Information is not asking for you a re-declaration. That's number one. So what you are doing, you are not really answering the Bill of Information. 2, the Bill of Information was not submitted properly. The petition for the bill, that was, in his own word, was through the back door. And thirdly, if you say this group is illegal, why? But they passed the budget. So are you saying you are eating illegal money? So that's from the dissenting opinion. It will be interesting, what people on the ground are saying and what our legal minds have to say.
Yeah. I think we can all, say emphatically that this is a victory for Speaker Kofa because the Chief Justice and the majority of the Supreme Court, that's all it takes, a majority of the Supreme Court justices to agree with you. And one of the things that she said was that the Bill of Information was granted. In other words, it was approved and what he was asking for was granted to him. Meaning, please clarify that I'm still the legitimate speaker and that these guys was acting outside of the Constitution. And the Supreme Court concurred with him. So that's a victory for him. That means he is the legitimate speaker in the eyes of the highest court of the land. So Unity Party cannot come in and tell us that it was a misinterpretation. And I think Oscar Toy, the Minister of Justice, has to be held in hard, in hard I don't know what's the word, but he has to be culpable for this misunderstanding because they used it.
What did Oscar Toy do wrong?
No, because Oscar Toy said that this was when the Supreme Court initially made a ruling using a lot of legal terms, using a lot of legalese, where the untrained layperson couldn't understand it. Oscar Toy, being the Minister of Justice, came on and said that this was a victory for the Unity Party, and the Chief Justice just emphatically said it wasn't.
Let's see. Prince, reporter Prince, reporter Prince, Mumbai is on grounds at the so what you see down there, that's Prince. So go ahead.
Oh, he's going to Musa now.
Prince, you are live.
I see you coming out with a very big smile.
We're excited.
Is this a win for you?
Yes, it's a win for the Constitution, it's a win for the rule of law, and it's a win for Liberia. I will first want to call on our colleagues to adhere to the ruling of the court for the sake of our democracy. Call on the President of the Republic of Liberia to mandate the executive to act in the mandate of the court and to restore all privileges to the Speaker of the 55th Legislature as law.
I think they're kind of lagging there with the video. But yes, honorability is reiterating what the Supreme Court said. And do you think, now the question is, do you think President Boyka has the gauze and the gumption to enforce this ruling? Do you guys think that's going to happen?
Well,
or are they going to misinterpret it?
Well, we're going to come to that. Let me see if we get Prince available again. Prince, where are you?
Well, while we're doing that, you have to while we're with Prince, we'll be getting input from others around. That was Musa Hassan Billet, the chairman.
Able to open the phone lines too to get the people here to get their opinions as well.
Right, the phone lines are open now. Let me put the number on the screen so we can hear from our people what you make of the Supreme Court Bill of Information, for the lack of better word, because the Supreme Court ruling.
Dennis, Musa is speaking down there. Do you want us to?
Yeah, please add it. I don't know why it's not. Yeah, I don't know why it's not added in. Can you try that again?
Yeah, let me try that one more time. I didn't stop it. Yeah. All right, so it looks like I have to stop it and start again. All right.
Looks like he's gone. He fell off again.
All right.
So in the meantime, let's see what people are saying in the comment. The Supreme Court cannot impose a leadership or speaker on the House of Representatives. Okay, we have Prince. The court is passing a political ruling that will have no effect.
Wow.
Yeah.
I mean, that's a blatant disregard of the court. And if we don't have our rule of law, we have nothing. We don't have a country. So how can you say that?
We don't even have the branches of government.
Jonathan said, Justice Bush's view of the Bill of Information, that is not a fact. As such, the Chief Justice decision is clear and final.
It is.
If the
I mean,
2025 budget
this
is
is relevant to
why the court receive salary. Glendy is saying, Lord have mercy. Friends, when you are ready, you can come, and if you want to join the conversation, 605.
That's very Glendy-ish.
The code is 791-4035.
Oh, we have a what's his name on there?
The bombastic
Arthur Johnson.
Arthur Johnson.
Can we get volume?
Yeah, friends.
Okay, I'm gonna go verbal. Yeah, it's on.
Fundamentally, reinvigorated and more solidifies the name and the acceptance of the Supreme Court in the minds of the Liberian people. Because the hope of the Liberian people was the Supreme Court. And that the clarity with respect to the interpretation of the law was functionally important for this particular case. Now that the clarity is made by the Honorable the Supreme Court, and that it had specifically clarified that Councillor J. Fonati Koba is the legitimate speaker, and that all actions taken by the majority black, headed by Rachel Cohn, are considered unconstitutional. This time they have not used the word Oxford Barrett that was misinterpreted, because many of our people don't understand that the word Oxford Barrett is a Latin word. Okay? And it also means illegal and unconstitutional. But the fact that the Supreme Court had associatively and definitively defined and said their action is unconstitutional, it cuts the case.
Now, also, you have five associate justices.
Yeah.
You have justices based on a concerning view and instead of issues that be raised, saying that bill of confirmation filed by the so what do you make of that?
It is a right of an associate justice to dissent. It's the practice in our jurisprudence all over. Dissenting opinion has no effect on the majority opinion. The majority opinion is the law. And so the fact that 4 justices of the Supreme Court, including the Chief Justice, to agree that the actions taken, the suspension, the passage of budget, the suspension of members, the attempt to remove members from ECOWAS, all of those acts are unconstitutional that have been approved by the 4 members of the bench. That is the decision of the court. And in fact, that is why the Supreme Court said they will not go and force each of the branches to say, don't follow the opinion of, let's say, follow the opinion. But the fact that every one of them took an oath of the Constitution to respect the executive is duty bound by law and Constitution and the oath that they have taken to respect the opinion of the court.
We are not talking about associate justice a dissenting opinion.
The dissenting opinion is his right. But let's look at the opinion. The dissenting opinion actually is the right of the associate justice to dissent, to disagree. That is the beauty of the practice of the law. But in any way, it's not an opinion of the court.
Yeah. Council, we have two courts of opinion, one from the citizens and one of the Supreme Court. So in your mind, what if the executive decide not to do business with your client who is
The first thing in history, we hold the executive responsible for disrespecting the law. One who is elected that violates the Constitution, that person his action is tantamount to impeachment. When you violate the Constitution, I don't believe that the executive branch will disrespect the opinion of the Supreme Court.
What is the move of the plan as a speech? So what next for your plan, Councillor Johnson? What next?
Funadi Sokoba remains the Speaker of the House of Representatives. Funadi Sokoba resumes and maintains his authority as Speaker of the House of Representatives of the Republic of Liberia.
We understand your plan.
The setting of Rachel Cohn is unconstitutional. Whatever he did is unconstitutional, which undermines the democracy and the pillars of our democracy. And it is now the time for them to set it right, because history has a tendency of judging people for violating the law, for disrespecting the rule of law. Because when the rule of law is broken, we have chaos. The only thing that oils the machinery of our social intercourse is the rule of law. And so it's that way and he is on obligation. And I don't also believe that Rachel Cohn will disrespect the opinion of the Supreme Court.
So I feel like it's just after Johnson, I still
But what's even more interesting is that this is a 4-1 decision. 4-1, not 3-2, but 4-1.
I mean, so
All right,
I mean,
gentlemen.
where do we go from here?
So
What
there
do
you
we
have it from
expect in the
the
coming days and weeks?
illustrious.
What we
I
think
thought
will
Johnson
happen?
talking about the social
That's a heavy
intercourse.
question. That's a heavy
I think the president has to take up the mantle of leadership and instruct the executive branch of government to enforce the ruling of the Supreme Court. It's the only way. You can't try to maneuver, you can't try to mangle your way out of it. You must enforce it. If he doesn't do that, then this president is he's utterly lawless. And then we can't trust him now to uphold the Constitution from this point forward. So this is a breaking point for him. For all the things he's been doing, he can come back to his senses and enforce this ruling. The Supreme Court is the final arbiter. Nobody else can judge, can give any other opinion to interpret anything else. It's very clear to we the simple people that Kofi remains the speaker. Everything that they did during that sitting was ultra violent, was out of bounds, was illegal, was unconstitutional, like the lawyer just said. And we the simple people, we knew that from the get-go. But Mr. Twer came and spoiled the whole thing. And the Supreme Court has brought us back to square one.
So, but if you think that in your view, if the president fails or the executive fails to enforce this ruling, right? The councilor is calling for impeachment. He said that's tantamount to impeachment. Do you share that view?
I mean, yes, if he doesn't, in terms of the law, he can be impeached because he took a oath of office, and it's his fiduciary responsibility. One of his highest responsibility is to uphold the Constitution, and the Supreme Court interprets that Constitution, and it just did that. And not upholding that Constitution would be a dereliction of his duty to uphold the oath of office that he took. So we have to assume that if he doesn't do that, he's not upholding the Constitution. Anybody who doesn't uphold the Constitution, they must be removed. That's my opinion.
And Michael, what do you make of undoing things, right? Number one, they made some appointments, they took over the office, they broke in Yaka's car and everything else. They also, what do you make of those things being undone? Well, what would the process be like?
Well, I've been a Liberian for more than 50 years, right? So, and I know Liberian people, right? They love to settle things. Basically, what I envision is going to happen is that Joseph Boyega now is going to try somehow to redeem himself. He's going to call Coon and say, look, you have lost. I'm going to try and save some face for us. And so I'm going to encourage you to come to a meeting with Speaker Kofa, and they will call both of them. Joseph Boyega will call both of them to a meeting. You'll sit down with them and you'll say, look, Kofa, this is what we need to do. The Supreme Court has spoken. You'll go ahead, we'll give you your gavel back. And like you promised, when you get the gavel, you want to, some of your immediate steps will be to then, accept whatever referendum or, that they will present and step down. And, and Speaker Kofa will have his list of things too. Like, look, these people stood behind me. They need to, all those representatives that were suspended, will be immediately reinstated. Their pay will be given to them, and then they will sit down and hash out. And Kun will say, look, people stood behind me too, so I need to protect them. They can't fall. And you say, okay, well, you know what? We'll divvy up the committees. We'll take this one, you take this one, and they will divvy up the committees. They will set a date for the convenience of Speaker Kofa to once more hold the gavel, and they will go through this process. But I believe, knowing from my Liberian background,
they will hang heads.
This will be settled. Huh? Yes, they will hang head, and they will settle. You'll see And the thing about it is that, I hear a lot of people talking about how, it will be difficult because Speaker Kuhn still has, I can't even call him that anymore. Richard Kuhn, I don't want to go against the Supreme Court. Richard Kuhn still has a majority of, Richard Kuhn never had a majority of anything, Those people are not loyal to Richard Kuhn. The Supreme Court has spoken, the powers are going to be switched. And once with power will go the flow of the river, you will start to see now those people who are sitting in the back choir. When Speaker Kofa calls for Tuesday sitting, all of them will go there and go sit down. Because guess what? There's a scramble.
I want to see the look on Thomas Fala's face when you have to go sit down on a Kofa.
Thomas Fala will come in with a great big smile. He will shake and bow to Speaker Kofa. And Speaker Kofa, knowing him to be an easy man, will stand up, shake his hand, hug him, and say, sit down. And that gesture, sit down next to me on my right hand side, it will be the end of all this stuff. You guys will this is like
I want to see that.
What the former TLA man is saying, James Nalasa, the court failed to be clear as it makes it hard for executive to enforce the ruling, since enforcement could begin with questioning justices on receiving money falsely.
Wow. Yeah, I mean, Mr. Lassa, you're a smart man. This is not unclear. This is very, very clear. A blind man in the dark room can see and can clearly hear what the Supreme Court said. It's very clear to us, sir. I think you're smarter than that.
But how difficult would it be for Kuhn? Let's say Kuhn takes office, but you still have people against him, and nothing stops the rest of these guys from sitting under the gavel. They can still sit out.
And then they'll be doing something that's unconstitutional. That's the point, Mr. John.
What do you mean? What do you mean? What do you mean by sit on which gavel?
If they don't want to go to meeting, if they still believe that Kofa they have lost their confidence, Kofa will still continue not to have quorum.
Yeah, he may not have quorum, but he's the legitimate speaker.
Yes, they have to understand. There's no more money. No more money coming from finance. It's clear. No more money coming from finance. As soon as these guys hear it, I'm not talking about people like the representative from Bon County or 40. I'm not talking about Representative 40, the hardcore guy. I'm talking about the quiet ones in the background that have not said anything, but they were just sitting on the Kuhn because why? They wanted their monthly salary and they wanted some kind of deputy committee position. Those are going to be the guys that will flee, and their flight will cause Kofa to have a quorum. Watch what I'm saying. Their flight will increase Kofa number from the 20s into the 40s. And once
Mr. Pablo, that's a selling point.
And talk about I think
once
11
Kofa
or
has
12.
quorum. Yes, once Kofa has quorum, at that point, Kofa can recall the budget.
Right.
Kofa can recall committee members. At this point, people are going to start. There's going to be a rush, a fight, because if you're the last person to cross over, when they finish buying everything, and I tell you, there's nothing there for you. You must leave now. So
Mr. Pablo, let me say this, right? Yeah, let me say this. Look, I think this is an easy exit route for most of these guys who you're talking about. This is an easy out for them. So say, you know what can I do? My hands are tied. The Supreme Court has spoken as the final, voice on this issue. I have to respect the Supreme Court judgment, and we have to go back and build the gavel of Speaker Kofa. Well, let me say this: there's one person in this whole thing that failed the president. That is the president lawyer. The lawyer to the president, not his personal lawyer, but the lawyer to the office of the presidency of the Republic of Liberia. And I think that is Bushi Ben Keita, if I'm not mistaken. Usually, in terms of in issues like this, where there might be a constitutional crisis, the president would lean on his legal counsel to give him legal advice on how to proceed. And he must have got some wrong advice to think that he could just do this the gangster way that they try to do it, and now it's backfired in his face. So I think Bushi Ben Keita has to be gone, and possibly the Minister of Justice has to be gone, because they misinterpreted everything, and they probably lied or led the president when it came to what his legal remedies were in this issue, because everything he did it wrong. He backed Speaker, quote unquote, Speaker Coon with the power of the purse, and thereby giving him, it's like flag going to something, and everybody came in and coalesced around him because he had a purse, and the president was the one who did that, and I think he really muddied the water by giving the purse to Coon, who by law and by the Constitution was not a legitimate speaker and should have never had the purse strings of our republic. So those are things we got to look at.
But Elvis, our country being what it is, don't you think that they told the president what he wanted to hear?
And that's the thing. You, as a lawyer, you have a again, I'm using the word, you have a fiduciary responsibility to give your client the best legal advice. And by not doing so, you are practicing legal malpractice. You can't try to tell your client what they want to hear rather than what the law states. You're there to counsel them on legal matters. So you have to give them your best understanding of the law sincerely. And that's why the bar can look at certain people, because if they give their client a wrong interpretation, the client when they did something illegal, and it was based on the advice of their lawyer, that lawyer could be in trouble. And I think in this case, it's probably what happened. Would you probably get the president, Mr. President? You're the president. After all, you're the executive. You have the power. The president, who you get a budget to, they can pass the budget, and that's not how it's supposed to be. So we got to look at that guy. Bujiman Keita has been leading the president wrongly. You saw what he did with a key, and now with this issue, I think if the president had Arthur Johnson by his side, he would have made a better decision than giving the budget to Coon.
Let's look at the CDC 12. What do you think they're going to be doing now? Or Michael, you talk about the silent group. So let's take the CDC 12, the CDC guys, for instance, like my own representative, who has a family relationship with my family man, or the representative of District Number 2, who's representing my district. I mean, I've never heard him, but he's kind of quiet. But he was on the Coon side, and
he will cross over, cross carpet. I was gonna say, like,
what's his name, Mr. John? What's his name?
Samson Weah.
He will cross. Samson Weah will cross carpet quickly and quietly. Tell how he went quietly. He will. Let me tell you what's happening right now. Let me tell you what. Let me tell you, because, like I said, I've had the honor to be a Liberian for over 50 years. Let me tell you what's happening right now, right? These guys, they still got a speaker number. So they will text the speaker, Speaker Kofa, they will text him. Honorable Speaker, congratulations.
Congratulations, I'm going to say.
No, nothing more they will put inside it. All they're telling you is like, your court session, we will be there. And then what they are going to do, they are going to hide behind the law is a law. They will tell you, say, when they question and say, oh, just yesterday you are behind Kofa and you are doing this behind Kofa, they will say, look, the Honorable Supreme Court has spoken. And as the legislator or representative of the people, I have no choice but to honor that. And they will move forward. That will be the out. They are listening to the Supreme Court.
Yeah.
And then they will start to fall.
And the man, if they eat the government money for free, they're giving no refund. All that enjoyment they enjoy is for free.
No, that one a free thing right there. All that will be buried. There's the problem with Liberia. All of that will be buried. All of that will be buried. Down to who went the billing, we shall never know.
Hey.
All that will be compromised.
All right. Let me get a council FOL legal analyst, Councilor Frederick Jewell. Councilor Jewell, I'm sure you follow what went down.
Not very well. I was sleeping when I got your text.
Okay.
So that's why I'm suggesting. I thought having a full opinion of the Supreme Court and holding a show on it would matter a lot.
Yeah. But the Supreme Court delivered, what seems to be in Funati Kofa's favor. And then we have one dissenting opinion, Justice Bese, who is saying, hey, you say the group illegal, but you got to check. Also, the bill of information was sent backdoor, and in fact, the bill of information did not request for you to be doing what you just did. So all these things we can discuss there in full, but I thought you may have some initial reaction.
When you say backdoor, what do you mean?
He said it was delivered, it was submitted improperly. And using his word, he said, using the Liberian parlance, that was through the back door. So I don't know what that meant.
If that contention is true, then the majority opinion is erroneous, meaning that in order for a bill of information to be accepted by the court, the rule is taking over to the Chief Justice office, but I think 3 justices so sign to ensure that the case can be brought back to the court. If that was not done, then there is, I don't know what, I hope he explained himself well.
Right. All right.
If that is what happened, then the court had no jurisdiction over the matter.
Thank you. But we're going to have a full discussion coming soon. You'll be notified. So that at that time, we hope to get the full Supreme Court decision so we can discuss it.
Yeah, I know. I mean, with the decision today, the question is whether the Secretary and the Legislature will follow what has been handed down by the court.
Is that optional?
Well, the executive could proceed by filing a petition for a motion for re-argument, and that would, if the motion is filed and 3 justices signed that the matter should be redacted, and the decision will not be enforced. So that's one option, legal option the executive or the legislature and the executive have. The other option is to agree to the decision of the Supreme Court and ask the majority to return to the chamber where Council Kofa, because Kofa is sitting, and then raise a motion to recuse himself based upon complaint they have.
Thank you. That's just a sneak peek of what's going to be going down right here on Focus on Liberia. Don't give them all, Councilor Joel. let them come back.
Yeah. Yeah, but I would like to see the opinion. I'd like to read the opinion.
Yeah.
It appears to me justice basically raising some key issues, and if those issues are true, for example, if the bill of information was improperly filed, then the court has no jurisdiction, then everything they did today will be unconstitutional. And so a motion for re-argument can be brought back.
Mm-hmm. And if it is still 4-1, maybe that re-argument would not get in because 3 will refuse to sign.
Oh, you don't know Liberian politics. Before that,
money will pass in for them to change their mind.
No, I'm talking about the legal side. So legally, if it is not signed by 3 justices, it can come on the docket.
It can be put on the docket.
No, if it is not, I mean, if the 3 associate justices, including the justice, don't sign, then
right.
it cannot be anything that the court will listen to.
Right.
But if those issues, I mean, I think Justice Bissett appeared to go deeper into the integrity of the court. Whosoever admitted the bill of information, if they're showing that the 3 justices did not sign, and only the Chief Justice brought it on the floor, and Justice Johnson, CNN, Clinton Johnson, Justice Wolokoli, and herself with Kabab, but Justice Kabab participated in this as a majority opinion, then they have just injured themselves more. Politically, they will have a problem. But you should know that somebody want to be Chief Justice, right? When Justice politically when Justice Yo retires.
Yeah.
So maybe quick judge. I mean, I'm not sure what he's saying is a fact.
Yeah.
But if it is a fact, then that's a problem.
Thank you.
Yeah.
Thank you, Councillor, and we'll see you soon.
Quickly, they're trying to save itself.
Yeah, but wasn't he speaking against the speakership that he didn't agree with it, and that's why he wasn't sitting on it? So why now? What meeting did they have in the next time?
He's not speaking about that. He's speaking about the bill of information.
No, but the bill of information that disclosure was made by Justice Wisse.
Right.
Justice Wisse, who has come to be known as the liquor talk justice. Why? Because he went to Nima or the opening of the court,
right,
and that was the first time we got an insight into the thinking of the court.
But what he said did not invalidate what he said in that liquor talk.
Exactly. But what I'm saying is that it's almost as if Justice thinks that the United Party-led government is going to blame him for all of this, and because of that, he will not get the Chief Justice position. This is his attempt to redeem himself. So he said,
"That's your opinion."
Yeah, that's your opinion.
I'll give you opinions today.
But let me say one more thing. One more thing that I was disappointed at. Look, number one, the microphone has to be better in the Supreme Court.
Yeah,
they have to have better microphone. And number two, I mean, these are legal luminaries in our nation. They have to be able to read coherently. They have to be able to read consistently so we can hear what they're saying and not be stuttering over words. And I mean, come on, it was a poor reading. Even worse than what the Chief Justice did. The way Justice Wisse was reading, it was terrible. And he was speaking so fast, like talking so fast, we couldn't really even understand him. Even though we Liberia couldn't understand him. Imagine international people trying to understand this ruling. So I think it was poor. The performance was poor. Go back to the days of Jordan Lewis Court, where he was well educated and well articulated. We want to see our justices like that. But I mean, for Councilor J to say that the other four justices were, had something to trying to say like that the bill of information wasn't properly processed. I don't think that's true because we've been hearing it that it was before the court. We've been hearing it for a long time. So this was not on a secret. This was not some kind of covert thing that was happening. We heard it months ago that it was before the court and the court was about to rule on it. And it was suspended because the president asked for more time. So this was not something covert. So I think that should be thrown out the window. I think it went through the right process. He just didn't agree with it, whether by inducement or by legitimate philosophy or legal philosophy. But I think that's a question, Mr. Jha, we can get to on another time about the salaries that was paid to them illegally through the Coon faction.
Yeah, we'll probably get to it tonight, but we don't know whether it was submitted properly or improperly. But we will find out if the justice has any evidence. But gentlemen, we want to end it here.
Yeah.
Yeah, thank you.
Yeah, we got to clean up for tonight. Let's have a show tonight, please. We got to get ourselves prepared for tonight's show. I think it will be a big show.
So on that
is that possible, or is the schedule conflicting?
On that note, we're going to close with our song that says we're going to have a show. Yeah, we're going to talk about that because we don't want to promise anything on the fly and we don't do it. But definitely 7 o'clock we should be able to have a show on that. On that note, let's close with our song that says, whether you believe the liquor talk or the other one, we are all Liberians. Have a good day. And God bless.
Yeah.
We are